All right. Hey, folks. So we are back. I am recording this live. We are going to stream the sentence being handed down. I've just been following some of the coverage on the other areas, like in Twitter and some other places that are showing the thousands of nurses that are gathered around outside right now to support RaDonda. I can only imagine what she's going through sitting there waiting on this. But I wanted to bring up a couple of things before we get started. And again, if you have a comment, just pop it down here below and I'll put it up on the screen. But, there were some takeaways from this morning that I thought were really interesting. So if you weren't with me, I streamed the whole thing this morning, the whole hearing this morning. A couple of the takeaways that I had was that, RaDonda really does have a whole lot of support, and that's fantastic. But one of the things that I found was a little, I don't know, sassy was that the prosecution seemed much more angry about her coming out on the news and making the statements that she did between trials. If you don't know what I'm talking about, I can play a clip for you this afternoon when I do my roundup. But she came in between during the trial earlier, and she actually said something to the effect of, Mr. Funk doesn't know anything about nursing and he doesn't care about nurses, doesn't know anything about healthcare, doesn't care about her nurses. And it seemed like that was what was really bothering them this morning. I mean, they kept going on and on about it, even tried to get the judge to consider accentuating the actual sentence and making it a larger or stronger sentence with like a modifier, if you will. Those in healthcare know what a modifier is, but like to make the sentence even more toward the high end of the range, because they were ticked off. They were really upset by her comments. And that's what came through loud and clear. I mean, they argued and argued and argued the point. They even argued the point they really, really did not want the judge to consider diversion. And in this case, diversion means that the sentence would be essentially diverted, kind of like a suspended sentence. It works almost the same way. So they really did not want that to be considered at all, to the point that they took, and I know that it was really confusing there when they kept going back. I was furiously writing down all the statute numbers. But basically, their argument was, well, I know that this wasn't in what you could consider at the time, but they took this piece of code and moved it over here. So because they did that, then I don't think that you should be able to consider diversion. And the judge was like, well, you can't tell me what the intent of the legislator was. You have to tell me like what I have to go by what's actually here. I can't just go by what I think the intent was. And that came through loud and clear. I don't think that the prosecution won on that point, but we will find out. I know a lot of people have been watching a lot of chatter over the last few minutes, getting ready for this live stream to come up. And people are really supporting RaDonda right now. And I think the family does too. I mean, the family came off, of course, one of Rhonda Murphy. I don't know if you saw hers, but Rhonda Murphy, she said something really interesting. She said, a mistake is mistakes happen until they're a choice. And I thought, wow, so when does a mistake become a mistake, but then become a choice? And I think that that's the crux of this. And it's hard again to assume intent. You just have to go by what the law says. If you are convicted of something, there are sentencing guidelines that the judge must adhere to. Having said that, I think we are set up for an appeal regardless of the sentence. I think we're going to appeal, and I think that we should, because there are a lot of things that I think were super sketch and super sus about this whole thing, like the way it went down, the missing medication. Like there's just a lot of things that I don't like. I don't like Funk's ties with Vanderbilt. There are a lot of things that I don't like about this case. And I think that would actually, I'm not an attorney, but I do think would perhaps work in the benefit of an appeal. And let's see here. Okay. It looks, well, the family is back in now completely. And here comes some of the team. There's RaDonda coming in. She looks okay. She looks like she's holding up okay. which I don't know how she's doing it, but good for her. So she appears to be holding up okay for right now. Okay, just waiting. Come on, Judge. Oh, good. She's smiling. Good. Hopefully, she's finding a little bit of peace and comfort throughout this, as I hope the family are too. I know it's hard on everybody. This is just such an unfortunate situation all the way around. Again, if you have any comments or thoughts, draw.
All rise. Be seated, please.
Here we go, folks.
Okay. So this case came today to be heard for the sentencing of the defendant, RaDonda Vaught, on her conviction following a jury trial of impaired adult abuse, a Class C felony in violation of TCA 71-6-119, and criminally negligent homicide, a Class E felony in violation of TCA 39-13-212. In determining the appropriate sentence for this offense, this court has considered the evidence presented at trial and the sentencing proceeding today, the pre-sentence investigation report and all corrections and additions to that report, the sentencing considerations outlined in TCA 4035-103, the nature and characteristics of the criminal conduct involved, the evidence and information offered on enhancing and mitigating factors, the defendant's statement here at sentencing, and the defendant's potential for rehabilitation or treatment. From all of this, the court finds as follows. The parties have agreed that the defendant is a Range 1 standard offender pursuant to Tennessee Code Annotated 4035-105, subject to a sentence range of 3 to 6 years at 30% release eligibility for a Class C felony, which is the impaired adult abuse conviction, and 1 to 2 years at 30% release eligibility for a Class E felony, which is the criminally negligent homicide conviction. By statute, this court is required to impose a sentence within those ranges. In making that determination, the court is required to consider but is not bound by two guidelines. Number one, the minimum sentence within the range of punishment is the sentence that should be imposed, because the General Assembly set the minimum length of sentence for each felony class to reflect the relative seriousness of each criminal offense in the felony classifications. And two, the sentence length within the range should be adjusted as appropriate by the presence or absence of mitigating and enhancement factors, as set out in Tennessee Code Annotated 4035-113 and 114. So with those considerations in mind, the court has considered evidence supporting statutory enhancement and mitigating factors. The state proposes that enhancement factor number 14, that the defendant abused a position of public or private trust, is applicable. Ordinarily, this circumstance applies in situations in which a defendant has specific or unique access that permits the commission of an offense. Examples of those types of cases are sexual offenses committed by caretakers, which was a situation in State versus Kissinger, which was the case cited by the state at argument. Other situations include where a defendant has access to internal record counts and uses that access to commit financial offenses or forgeries. State versus Franklin, 919 Southwest 2nd, 362, and State versus Finch, 465 Southwest 3rd, 584, are examples of those types of situations. Application in those types of contexts and the use of the term abuse in the enhancement factor itself suggests to the court that a higher level of culpability than simple criminal negligence is required to meet the standard, and thus does not find that this particular enhancement factor applicable to count 2, criminally negligent homicide. As to count 1, impaired adult neglect, the court also declines to apply the factor because the caregiver or trust relationship is an essential element of the offense and may not be duplicated through enhancement. The court has also considered certain mitigating factors and has heard proof on those today. The defense first proposes application of factor number 11, that the defendant, although guilty of a crime, committed the offense under such unusual circumstances that it is unlikely that a sustained intent to violate the law motivated the criminal conduct. The court agrees that this factor is applicable here. This offense occurred
That's good.
in a medical setting. It was not motivated by any intent to violate the law, but through oversight and gross negligence and neglect, as the jury concluded. The defendant also accepted responsibility immediately. She made every effort in the moment that she recognized her error to remedy the situation, to notify the appropriate individuals, and then later to ensure that all of the facts and details were brought to light. The court has also heard proof today on the catch-all enhancement factor, factor number 13, and finds several circumstances applicable under that provision. First, the court observes that the defendant's acceptance of responsibility immediately and her remorse throughout this proceeding support application of factor 13. Testimony and letters from friends and colleagues attesting to her work ethic, her character, her kindness and generosity also support application of this factor. The court has also considered the fact that Ms. Vaught will never again be in a position to repeat this fatal error. She has been stripped of her nursing license and has started a new livelihood outside of the healthcare profession. All of these factors and considerations support the application of the catch-all mitigating circumstance number 13. The court has also considered the Murphy family and their terrible loss. Nothing that happens here today can reverse that loss or ease that pain. And I have seen from my own experience, not only on the bench, but in my previous practice experience, that sometimes it seems that the attention in criminal cases tends to shift as the case goes on from the victim to the offender. In this particular proceeding, the attention is obviously on Ms. Vaught because I have to determine the appropriate punishment and result and outcome from the jury verdict. But I want to assure the Murphy family that this court is deeply mindful and sorry for their loss. It is my hope that changes in the practices and protocols in the medical setting that have arisen since this event may at least be some positive aspect that has arisen, and that going forward, I hope that it prevents this type of situation from happening again. I recognize, however, that that will never be enough to heal your wounds. Considering the applicable mitigating factors here and the absence of any applicable enhancement factors, the court will, as to count 1, impaired adult abuse, set the sentence at 3 years. As to count 2, the court sets the sentence at 2 years for criminally negligent homicide. This is the maximum amount of time allowable by law that this court would be allowed to impose for criminally negligent homicide. And the court does so in recognition of the terrible loss sustained by the Murphy family. These terms will run concurrently, there being no evidentiary or statutory basis in this case for consecutive sentencing. So the sentence in this case will be an effective 3-year sentence. The court has also considered whether to grant or deny alternative sentencing. The law requires that the court consider alternative sentencing regardless of whether it's requested. And by statute, the court has to consider a number of specific elements. The court has done that. The court finds that the defendant's potential for rehabilitation is great. The court further finds that the defendant will likely abide by the terms of probation based upon the testimony before the court, based upon the information in the pre-sentence report, which places her chance of recidivism as low and the need for intensive supervision as low. The court finds that the defendant is not likely to reoffend. As I stated earlier, she's no longer in a medical setting. She no longer possesses a nursing license. The court also does not find that a probationary sentence will unduly depreciate the seriousness of the offense. The proof at trial and the proof here at this sentencing demonstrated, I think, that Ms. Vaught is well aware of the seriousness of the offense. She immediately and consistently accepted responsibility for her actions, and she credibly expressed remorse in this court. The more challenging issue for the court has been the question of judicial diversion.
This is important.
Specifically, whether the defendant is even eligible for diversion with respect to count 1. The defendant in this case was charged and convicted for a violation of Tennessee Code Annotated 71-6-119. The offense was committed in 2017. On May 24th, 2019, Governor Bill Lee signed into law Chapter 2019 Public Acts, Chapter 474. That act was entitled the Elderly and Vulnerable Adult Protection Act of 2019. With respect to Title 71, the act amended Tennessee Code Annotated 71-6-124, which addresses a circumstance that's unrelated to this case. But notably, the act expressly and I quote, deleted in their entireties, sections 71.6, 117, and 71.6, 119, the provision under which the defendant was convicted here. Those crimes, the 71.6, 117, and 71.6, 119, no longer exist. They were replaced by new offenses that are similar, but they are not the same. Tennessee Code 71.6, 119 is no longer excluded from diversion under Tennessee Code annotated 40.35.313.
That is good. That is very good
Perhaps
for her.
that it was the intention of the legislature that it still be excluded, but it was not by the plain language of the statute. The legislature was surely aware of TCA 40.71.6.119 when it amended 40.35.313 and when it adopted the Elderly and Vulnerable Adult Protection Act of 2019. And it could have kept that code section in the list, among the list of excludable offenses in 40.35.313, but it did not. And this court does not have the authority to look behind the plain language of the statute and try to glean an intent that is not expressly stated in the statute. The court thus concludes that an offense under Tennessee Code 71.6.119 is no longer disqualifying for purposes of diversion. Again, whether that was an oversight or mistake or whatever the intention of the legislature was, the legislature speaks through its acts, and this court can't second guess or go behind the plain language. The defendant has requested diversion for both offenses in this case, and the court has considered the factors set out in State versus Electroplating, 990 Southwest 2nd 211. The factors that the court are required to consider in determining whether to grant a judicial diversion are the accused amenability to correction, the circumstances of the offense, the accused criminal record, the accused social history, the accused physical and mental health, the deterrence value to the accused as well as others, and whether judicial diversion will serve the interests of the public as well as the accused. With respect to the circumstances of the offense, the court finds that there was no sustained intent to violate the law, and that the defendant is highly amenable to correction. She has no criminal record. She's been removed from the healthcare setting. She will never practice nursing again. This situation will never be repeated by Ms. Vaught. Court is particularly concerned about the deterrent, or has looked most carefully at the deterrence value to the accused as well as others, and whether judicial diversion will serve the interests of the public as well as the accused. Court does not find that a denial of diversion will in any way undermine any deterrence. In fact, there's no deterrence value by denying diversion in this case. This was a terrible, terrible mistake. And there have been consequences to the defendant. Serious personal consequences, financial consequences, professional consequences, and now public consequences in a criminal setting. Court also does not find that judicial diversion would in any way undermine public interest. Again, this is not a situation that involved any sustained intent. And changes, modifications, responses that have occurred as a result will certainly serve a greater value in preventing a reoccurrence than by denial of diversion in this case. The court therefore finds that judicial diversion is appropriate and will enter an order today placing the defendant on supervised probation for an effective period of 3 years, and will defer entry of judgment pending successful completion of that probation. And that will be the order of the court.
All rise. Court stands adjourned until Wednesday morning at 9 a.m.
Well, there you have it. I'm sorry, I'm a little emotional hearing that. She was basically, her sentence was suspended. And that is amazing. That's what we wanted. So she will have probation for 3 years. She was sentenced to the maximum of offense C, felony C, and felony E. Both were 3 and 2 years respectively, which would end up being run concurrently for a total of 3 years. And the judge listened to the enhancing factors and the mitigating factors, and ended up saying, you know what, I believe her. I think she has a high chance of recidivism. And because of that, she gets diversion. She got diversion on both of them. So what this means, though, is she will be on probation for 3 years. So she'll be on probation for 3 years. At the end of that 3 years, they'll go back to court. They'll look at it and say, okay, did she do what she was supposed to do in those 3 years? Did she violate her probation in any way? And if she does not violate her probation, she does what she's supposed to do, then they will enter in a final judgment at that time. So it's going to be very important for the next 3 years that she not commit any offense. Again, I agree with the judge here. I don't think that there's a high chance that she's going to do that, but that is what the decision was. I am sure that people are screaming outside on the lawn right now, and I am there with you. Eva, same, woohoo, absolutely. Yes, it is excellent. I am so glad that this was the outcome of this case. The judge considered all of the evidence, and I am okay with the extra hour that she took, because it came across to me like she really considered the evidence. She really considered the law. She really considered the statutes and what her responsibility as the court was to do in this case. And I think that she took that very seriously. And of course, I'm biased here because I agree with the outcome, except for I think the whole thing should just be completely set aside and done away with, like whatever, because I don't agree with the charges to begin with or the conviction to begin with. But it is the best that we've got now, right? So now she can, at least from this point forward, I'm sure that her attorneys will still probably work on something going forward. It'll be interesting to see what her next steps are.